Welcome back to Winning Isn't Easy. Do I have to tell my ERISA disability insurance company about all of my medical problems if I'm claiming ERISA disability benefits? Filing an ERISA disability claim involves lots of medical documentation, including your medical records, your test results, and even operative reports. And as a matter of course, I tell my clients that they should tell the disability carrier about all of their medical problems, regardless of whether or not those problems may individually be disabling or even be potentially related to what you think the primary reason is that you're unable to work. So let me give you an example. You might have a heart condition and diabetes, but your diabetes is under control. Your diabetes in and of itself may not be disabling for ERISA disability purposes, but the combination of the diabetes and the heart condition very well could qualify you for your ERISA disability benefits. That's why I think it's better to disclose all of your medical problems. Now, there aren't any rules or regulations that require you to inform the carrier of all of your medical problems. But again, as I've said, I think it's better as a matter of course to disclose them all, and then they can be winnowed out, if you will. What's your attorney's obligation to submit medical evidence? Now, you may have retained an attorney to represent you, and you may be wondering what the attorney's obligation is to submit medical evidence, even if it's unfavorable. I want you to remember that in the Social Security context, a Social Security attorney who may be representing you is required under the Social Security rules and regulations to obtain evidence and submit all the evidence, including factual information, medical source opinions that relates to the question of whether you are disabled or not. And that includes bad things. And they can get in big trouble if they don't. There's no hiding the ball in the context of a Social Security disability case. Now, in the context of an ERISA case, there's no affirmative obligation by rule or regulation that the attorney has to provide the carrier with unfavorable evidence. But I assure you that you and your attorney is going to be asked to provide the disability carrier with a complete list of your medical providers because they're going to go get the medical records. If you have cherry-picked your medical records, pulled out the bad stuff and sent it to the carrier thinking, I fooled them, you're in for a rude surprise because they will get your medical records and they will see the things that you specifically pulled out. The unfavorable records will come with it. I think hiding the ball is hard in an ERISA case. And quite frankly, I would rather deal with an unfavorable medical evidence up front than hide it. I'd rather have us address it in the form of statements or have your doctor address it than hide it. Hiding the ball makes you look like a liar, questions your credibility, and gives the disability carrier a reason to deny the claim, in part because you haven't cooperated and you haven't been truthful. Don't you agree? Let's take a break.
Are you a professional with questions about your individual disability policy? You need the Disability Insurance Claim Survival Guide for Professionals. This book gives you a comprehensive understanding of your disability policy with tips and to-dos regarding your disability application that will assist you in submitting a winning disability application. This is one you won't want to miss. For the next 24 hours, we are giving away free copies of the Disability Insurance Claim Survival Guide for Professionals. Order yours today at disabilityclaimsforprofessionals.com.